Let's talk about a recent case that highlights just how important it is to keep good records when you're serving as someone's attorney-in-fact. In Michigan, a woman named Cynthia was appointed under her mother's durable power of attorney. She had broad authority to manage her mom's money, property, and even hire professionals to help. But things went sideways when her mother claimed she had moved out of Cynthia's home because of financial mismanagement and mistreatment. The court suspended Cynthia's powers and ordered her to account for everything she had done over the past few years. When Cynthia filed her accounts, the court found huge problems. She had taken out more than $55,000 in unexplained cash withdrawals, spent her mom's funds on her own property taxes, credit cards, airline tickets, and even groceries. She also disguised some expenses to make them look like caregiver payments. In total, over $100,000 in spending couldn't be verified. The court ruled that she breached her fiduciary duty by failing to keep accurate records and mixing her mom's money with her own. Now, that case was in Michigan, but the lessons apply everywhere, including here in Massachusetts. Under Mass law, when you accept the role of an attorney-in-fact, you take on fiduciary duties: the duty of loyalty, the duty to act in good faith, and the duty to use diligence and care when managing someone else's money. Even if you think you're acting in good faith, failing to keep proper records or keeping the principal's money for yourself can land you in serious trouble. Here are some practical tips for attorneys-in-fact in Massachusetts. Number 1, keep meticulous records. Track receipts, payments, cash withdrawals, and who got paid for what. If you're paying caregivers directly, get a receipt. Issue a 1099, keep everything organized. Number 2, never treat the principal's money as your own. Reimbursements are only safe if you can prove the expense was truly for the principal's benefit. Number 3, communicate with the principal whenever possible. And if they're incapacitated, expect that a court-appointed guardian or conservator may review your actions in the future. Transparency is key. Number 4, remember your role is to preserve the principal's estate plan, not rewrite it. Big gifts, transfers, or changes to assets are usually not appropriate unless the power of attorney specifically allows them. And finally, get legal advice early if you're unsure. Courts hold attorneys-in-fact to a high fiduciary standard, whether you're a family member or a professional. So the Michigan case teaches us failing to keep records and commingling funds will be treated as a breach of fiduciary duty. Here in Massachusetts, the same duties apply. Stay safe, keep records, avoid conflicts, and always act in the best interest of the person that you're serving. I want to thank you for watching, and if you found this helpful, subscribe for more Massachusetts estate planning insights, or reach out if you'd like to talk about how a power of attorney might fit into your estate plan. Thanks for watching.